Strathfield James.
Please, my lords. Something approaching warp speed before lunch. I tried just to explain in very brief outline that the J101 code applied to the whole tower and to an optimization or integration process to be carried out by the turbine manufacturer. And that's, in my submission, is the starting point for understanding how J101 actually works. The second stage is to see how the technical requirements and J101 fit together, and for that purpose to look at some of the bits of the technical requirements in J101, and I hope to answer my Lord Newberger's query is how one gets to a nominal failure level and nominal annual probability of failure, because it's not just a matter of assessment and someone having a look at it. So if we can do that first, the way that the technical requirements work in this respect, my submission, is if one goes to I5 at page 354.
Yep.
And under
Page 314, did you say?
354, I'm sorry. We've seen bits of this before. It's 1.6 key functional requirements. We saw the first paragraph very quickly before lunch. Mr. Marin showed you the second paragraph.
Yes.
The third paragraph, that we haven't, I think, looked at, the works elements should be designed for a minimum site-specific design life in inverted commas of 20 years without major refits or refurbishments. All elements should be designed to operate safely and reliably, and so on. And then if one goes on from that, obviously identifying that it says design life, as you've seen quoted before. If one goes on from that to page 364, in the design principles, (321) at the top, one has the design of structure should be in accordance with the design codes and standards detailed in section 323. That's at 366. And at 3231, one sees it's J101.
Yes.
And then finally, for this little linking, penultimately, at the top of the page at 3222, first paragraph, we've got the bit that Mr. Marin showed you and I showed you shortly before lunch, which tells you that it's going to be one of the particular procedures within J101. That's the direct simulation of the combined load effect of simultaneous load processes. That's the second line. And then finally, at 368, so over the page, 3.2.6, one has life. All parts of the works, except wear parts and consumables, should be designed for a minimum service life of 20 years.
Yes.
So the designer is given within that certain instructions which are relevant to J101 in relation to life and the process to be adopted. And if one then looks quite swiftly, I hope, at J101, at K2, 760, beginning of J101, and if one goes within that to page 777, Design Principles, Section 2.
Yep.
And in A101,
A101 we didn't look at.
the top of the page, you see there in the second dash point is the design by partial safety, which is the particular matter that's picked up. We saw at the first paragraph of 3.2.2.2 a moment ago. And you see effectively there are four ways that you can, within the code, design. You can have partial safety factor method with linear combination. That's not us. The second one is us. Or you can have design by testing, or a pure probability-based design. Now, the pure probability-based design is not us, but it's useful to know what it is. Effectively, what that means is that you decide all the parameters and probability parameters from first principles. And so you'd have to establish, in accordance with other codes which are set out, all the probability cases which would enable you to carry out a probability-based design. But perhaps not surprisingly, here they've gone for the, as it were, the bespoke J101 option, the second one, the partial safety factor. And then secondly on that page 777 in C, one has the target safety classes and target safety level. Target safety level is defined at page 772. If one looks in C100, or C, the heading, target safety level, and then the words are used, and 772 is the definitions. And target safety level is the nominal acceptable probability of structural failure. Page 772, paragraph 280, in the left-hand column.
I see. A nominal acceptable probability.
Yes. Now, the word nominal is quite important.
Sorry, I can't find that.
I'm sorry, my lord. On page 772, paragraph 280, about a third of the way down.
772?
Yeah. It's the definition section, I'm sorry.
Oh, I see.
Nominal acceptable probability of failure, of structural failure, is the target safety level. And the word nominal is quite important. It means, if one wants to try and get a synonym, which is never a very good task to embark upon, theoretical. It means calculated in accordance with received standards, which can be compared with safety cases. So it's not trying to work out the actual probability of failure in any particular year, because that wouldn't be possible, because it would depend upon the actual loads. What you're trying to do is work out a theoretical level of probability, which you can compare with safety cases. And so if one goes back to 777, page 777, C, safety classes and target safety cases, you can see in 101 that in the standard, the structural safety is ensured by use of a safety class methodology. And the structure is classified into a safety class based upon its failure consequences. And to paraphrase the following paragraphs, effectively, and general principles, effectively, if you have people on board and there's a risk of damage to people, that would be very serious. If you could do serious damage to the environment, that would be quite serious. But in relation to wind turbines, which are generally not manned, and at the time they're most likely to fail is probably during a storm, there's not even going to be anyone there for maintenance, they have relatively low safety cases. And if one goes down to target safety at C200, at 777, we can see this is a passage that Mr. Marin drew your attention to. We've got there the target safety levels because it's the normal and low safety classes. That's because the platforms could be manned and they're normal and low for the turbines. And so you have the range of 10 to the minus 4, 10 to the minus 5. So the way the standard works is that there are some target safety cases that give you a nominal annual probability of failure. And using the standard and the statistical work that underlies the standard, one can produce comparable nominal annual probabilities of failure to see whether one fits within the requirements. And to show you how that works, just to do it for the ULS and the FLS, but quickly, the idea is to model loads and compare them with resistances. And you always want your loads to be less than or possibly equal to your resistances. It's what's referred to as the design inequality in the standard. And so what you do for each of the two cases, for ULS first of all, is you build up the loads. So if we look at ULS loads, these are the extreme events. So you're looking at essentially the probability of an extreme event. It's not directly time related. And if you go to page 780, you have what's called the characteristic load effect. And the characteristic load effect, if you go in F300 on the right-hand side, characteristic load effect, F301, go to the last 3 to 4 lines, there's a sentence that starts, in the case of ULS design, the characteristic combined load effect should be taken as the 98% quantile in the distribution of the annual maximum combined load effect. The combined load effect whose return period is 50 years. So this is, if you like, the primary provision. We saw the table, the B1 earlier on, that had a little box, and my Lord Newburgh pointed out at the bottom that it was 1 divided by 50, or it was the 2% that remained from the 98%. This is the requirement that one uses that, and one could go to the table at page 792, which is the one we saw before. We don't need to go to it now, to pick that up.
Yes.
To that load factor, that's what's called the characteristic load factor, load effect. One applies a load factor to allow for the fact that although you've got a statistically unlikely event, it's only a 0.02 nominal annual probability, you might be wrong. It could be a bigger storm or something else. So you apply a load factor, and that will cover the sorts of things. If one looks at 779, page 779, paragraph 210, load factors account for possible unfavourable deviations from the loads of their characteristic values, the limited probability that different loads exceed their respective characteristic values simultaneously, and uncertainties.
And the relevance of this, the precise point of issue in this case?
I'm going to do it very quickly, I hope, for this in ULS, but the point is ultimately quite a short one. What one does within this, it was to try and answer your Lordship's question earlier on, what one does within the code is come up with, on the back of a series of statistical models, so both the likelihood of the event, the load factors, the material factors, and so on, a probability calculated in accordance with the code, which is a nominal annual probability of failure. That's got behind it, as it were, a mass of statistical evidence. And if one combines the ULS and the FLS, one will get a figure, which is the theoretical probability each year for a design life of 20 years of failure. And one can compare that with 10 to the minus 4, 10 to the minus 5.
Compare that with what?
With the target safety level, which is 10 to the minus 4, 10 to the minus 5.
What I haven't got in my mind is, were these factors or requirements actually breached? I mean, if they weren't, why not? I mean, on the face of it, it couldn't stand quite ordinary loads.
2 points, or 3 points perhaps. The first point is there's a certification procedure that goes through the modelling of all of this, all the loads, all the statistics, and that was signed off by DNV at the time, and it was in fact certified, the final certificate was issued after the failure had been discovered, and the effect of that certificate was that it was in accordance with the standard. The second point was that there was a challenge, as my learned friend said sometime during the course of the morning, on the effect that the design had been prepared negligently. That was the subject matter of most of the 2 weeks that we had before the judge, who said that we had misapplied the standard in various ways because, for example, these are big circular annulus type structures. And just to give you one of the examples, there's a ratio between the diameter of the structure and the size of the steel, which is quite important. And it was said that we'd exceeded that and negligently and so on. So that was the sort of topics. That's the second thing.
But the negligence, is the negligence relevant? These appear to be requirements that the design produces a 1 in 50 probability.
No, the requirement, and that's why the word, in a respectful submission, nominal is important. The only meaning
nominal one
is within the standard and by comparison. And that is applying all the design equations, the parametric equations, the design inequalities, the load factor, whatever, within the standard.
So it's just that these standards happen to miss this particular defect. They didn't measure it, and it wasn't picked up by the certification, therefore.
Well, no, I wouldn't put it quite like that, with respect, my lord. What happened was one of the design equations, the parametric equation that you drew attention to earlier on, and contained within it an error in one of the variables, delta, which resulted in an axial load of 1/10 of what it ought to have been.
So the answer is that that's a parallel requirement to this rather than an overlapping requirement, and the parallel requirement is one you say you complied with because it's specified.
It might be one way of looking at it. Another way to look at it is to say that absent a warranty that we guarantee the standard or that we guarantee the life or whatever it would be, we have produced a design that is compliant with the standard, that gives in accordance with the standard a nominal probability of failure.
It does come down to the basic point that you say you designed in accordance with this, didn't breach any aspect of this, and they say that's not good enough. There's an overriding absolute duty.
Yes. And importantly, just to pause there, as I've understood the case, at least until the Lordship started putting perhaps a slightly different version to Mr. Marin earlier, and his I'll think about it with the nonny question that my Lord Neuberger mentioned.
Yeah.
Until then, I think it had always been put on the basis that the breach of the absolute obligation occurred when there was failure, so that it could be in year 15, say, but there wouldn't be a breach beforehand. One of the reasons there wouldn't be a breach beforehand is that one couldn't tell, of course, whether it would fail in the abstract, because you had a nominal annual probability of failure. And it may or not fail in year 15. But that's not a case, I think, that was adopted by my lady friend, or certainly not one that's been put to date, but perhaps we'll have to come back to that. So to answer my Lord Neuberger's point, the relevance, perhaps I can take it more quickly, but I was aware that I think it was Lord Mann said we haven't seen J101.
No, I'm sorry, this was ignorance.
Well, it's not everyone's bedtime reading, or
No, I think we've seen enough extracts from it, but
perhaps we can take the other half very quickly. The same process occurs for fatigue loading. For fatigue loading, as is set out in very brief form in our statement, in our case, here it is time related. For the ULS, it isn't time related, it's the probability of an event. But for fatigue loading, you build an expected or characteristic load history. Perhaps if we look at that at page 780.
And what has the judge found about this? As I understand it, he has found that it didn't have a 20-year service life. So he has accepted the allegation of breach as Mr. Marin has formally put it. Well, you accept that, presumably?
I mean, the foundations had 1/10 of the axial load and started slipping very soon after construction.
And therefore they don't have a 20-year service life.
Well, that goes to the question of the warranty, my lord.
Yes.
We say that there isn't a warranty, that they should have a 20-year service life.
Yes, but I mean, that's the critical issue. I mean, taking up the question, where do these observations about load factors lead? The critical issue is whether there was an obligation to ensure that it had a service life of 20 years.
Indeed.
And that, as I understand it, is not affected by the points that you've been making about load factors and so on. That may explain why we're in this situation, but it doesn't actually go to the issue we're concerned with, does it?
It goes, with respect, when it comes to construing, particularly 3222,
Right.
to understand what it means. One of the things that the parties would certainly have had in mind is the approach that was taken under J101. If J101 had contained different provisions, not probabilistic provisions in the way that I've described, dealing with a nominal annual probability of failure, and were consistent with a warranty, and the warranty was set out, the position we say would be different. The question as to whether 3222 in particular contained a warranty is to be looked at against the background of a proper understanding of what J101 contemplated by way of design. That's the way that we put it.
I suppose all the specific design obligations are what you say dealing with matters other than J101, covered by J101, or do they overlap?
I mean, look at obviously at the TRR section in a moment,
Yeah.
the TR section in a moment. But broadly speaking, if one looks at 3222, this is a point that's made in our case, each one of those are telling the designer to do something. The first one is telling the designer to use the combined method. Perhaps if we look at it briefly now. Page 366.
Yeah.
So I can come back to the why it matters, at least to show your lordship how we're going to put this bit of the case. It was partly in response to what was being said this morning that I decided to go to J101. But if one jumps ahead for a moment and get back to 366, 3222, the first paragraph requires, as we've seen, the use of J101 and a particular part of the design procedure within J101, which I've just been showing your lordships a moment ago. So that's the combined load effects and
Very
simultaneous
first bit, yeah.
processes. Yeah. And then the second part of it deals with the optimization, which I dealt with at some speed before the short adjournment. And that's the tower turbine contractor optimizing the tower. Leave for a second the important paragraph. If one looks at the third paragraph, this requires the contractor to ensure that the eigenfrequencies of foundation and tower are within allowable ranges. Now, slightly odd here because the tower is not his supply, so there's a slightly odd difficulty for him, but it looks like it's one of those provisions that's been perhaps carried over because he can only deal with the foundation. But leaving that point of detail to one side, what it's telling the contractor is that he has to look at the vibration frequencies, resonant frequencies, that are coming down from the operation of the turbine and the tower. And then the next paragraph, he has to make sure, perhaps obviously, that the flange between the tower and the top of the foundation has to match. That's the bolted flange that Mr. Marin told you about right at the beginning. And then he has to deal with the grouted connection and the appurtenance geometry. The appurtenances include such things as boat platforms and davits and so on. So within a section, you remember we saw the index to this, which is to dealing with design principles. Mr. Marin showed you the index and the way that it worked. So this is in a document, if one goes to 356, which is a design basis document.
Yes.
You have then in 3.2, starting at 364, design principles.
Yes.
And you have, after some scope, you have the tender stage design, where there's been an indicative design undertaken for the employer. And at 366, the detailed design. The paragraphs that I've just shown you, so ignoring the one that Mr. Marin particularly relies upon for a second, are all instructing the contractor how to carry out or what to take into account in its design. Look at J101, look at the following factors. Now, the way that Mr. Marin reads the second paragraph, the important paragraph, is different. It's essentially, as he would put it, a risk transfer. It is saying, instead of what you should do in design, it's saying you must take the residual risk of complying or producing a compliant design. And we say that actually, if you read it in its context, both the context which I was going to, and I'll just touch on a moment ago, which is J101, and its purpose and nature, but also in its context of the other paragraphs around it, this is simply telling the contractor to ensure that in every aspect there shall not be planned replacement. And it does use the words, obviously, ensure a lifetime of 20 years in every respect without planned replacement, but the way to read that is effectively putting a bracket around all of the words from a lifetime to the end. So what you have to ensure is a lifetime 20 years without planned replacement. Or putting it another way...
The words without planned replacement are simply an explanatory of the lifetime of 20 years, aren't they? The primary obligation is a lifetime of 20 years, and this is simply saying that you work out whether it ensures a lifetime of 20 years on certain assumptions as to whether there are planned replacements.
Well, can I take that in stages? Because we say no, not quite.
You reject that,
Yes.
do you? Yes, okay.
And the reason we reject it is, if I can try and deal with it in stages, is first of all, planned replacement is a term of art. That within the contract you can have maintenance, which you go and inspect and you find. But planned replacement is that you decide within a period of time that you will replace an item.
Yeah.
And you design on that basis. There's no doubt, secondly, that the
bolts or something.
It could be bolts, it could be a flange, it could be all sorts of things. But instead of designing them to last without replacement, they might get hit by a vessel and need replacement. There might be a big storm, whatever. But you're being told here, we say...
It's planned as opposed to accidental replacement, your collision.
Well, or just ordinary maintenance. It's dangerous to say unplanned.
Without ad hoc replacement.
Yes.
Yes.
Yeah. And was that a requirement of the contract, first of all? Well, yes. If one looks at... Sorry, we're a little out of order here. But if one looks at...
We've seen elsewhere, haven't we?
We saw at, for example, a moment ago, 354... Third paragraph. There you have design for minimum site-specific design life of 20 years without major refits, retrofits or refurbishments. In the key functional terms, obviously rather similar words. And one finds throughout this, Mr. Marin showed you, I think, two others, perhaps I won't go to all of them, but if one looks at, for example, I9.
I mean, the same point surely arises in relation to 354. You can't specify 20 years without indicating at least on what assumption you are making that, because you could, if you have enough retrofits and refurbishments, it will no doubt last 100 years.
Or alternatively,
so this is basically telling you on what assumptions you are to calculate its design life.
Yes.
But the operative provision of this, as on page 366, is the period of design life. The rest of it is simply an assumption for working out whether you've complied with that.
Well, I think, as I understand it, Mr. Marin would say that the lifetime of 20 years, an insurer lifetime, is more than design life. That's to ensure the service life, as he would put it. Mm-hmm. So we would like, if you like, the formulation that I think your Lord just gave at 354, where it talks about a minimum site-specific design life of 20 years, because that's exactly what happens with J101. What's said against us, as I understand it, is that very importantly at 3222, second paragraph, there it's a warranty to ensure a lifetime of 20 years,
right,
which is a different kettle of fish altogether. It's not to design in accordance with J101, assuming, for example, for fatigue life, 20 years. It's to promise that you will be liable if the structure does not last 20 years. You can't, of course, ensure, with the design, that you'll get a lifetime of 20 years. That doesn't make sense. This is, as I understand it, read as being a transfer of risk in the event of failure within the 20 years. And so, first, as a matter of construction, we say that if you read the second paragraph, in its context as part of what this detailed design is doing, it is not transferring all the other provisions into warranties. It is simply identifying that there has to be a planned replacement, but not in the context of an insured lifetime of 20 years. You find the requirements for design elsewhere.
I suppose you say the next two paragraphs on which some reliance is placed, subparagraphs of 3.2.2, are, if they are undertakings, they're easy to comply with in the sense that they are one-off. Either they don't extend over a period. Either the eigenfrequencies are within the allowable ranges, or the diameter of the flanges does match, or they don't. Is that the difference?
Yes. So it's
telling you. I mean, they aren't framed in terms of design, but it doesn't matter because once you've designed it, it is and will remain from the beginning. It's not a continuing warranty, as is suggested in relation to the second subparagraph.
Indeed, and if one goes back a second to, I think it was my Lord Sumption, or perhaps it was my Lord Newberger said, why are we looking at J101 at all? And I gave two parts of an answer to that. One is because I thought it might be useful to look at it, and the other was because it's the background to the construction of this. And one sees that in the first paragraph at 3.2.2.2, obviously J101 is being called up with a particular design code. So one has to think how the second paragraph fits with the first paragraph. If, for the reasons I'm giving, J101 gets you to a nominal annual probability of failure, which is used only for assessing against the target safety levels, and that's what the first paragraph is dealing with, coupled with the obligation I mentioned before lunch, which is the optimization of the tower, which is within the same code. It's all to happen within the same code. All of that is looking for a tower plus foundation structure that has a nominal annual probability of failure. So that's what the first paragraph is getting at. It's then said that these words in the second paragraph effectively change that into the warranty. And one can see the words insure and lifetime of 20 years. And one can understand my Lord Sumption's point about the words with respect. But if one tries to read them in their context, first of all, context both of J101, which is the points I was trying to make before, but also in the context of these paragraphs and what they're doing, they make sense as an instruction as to the basis upon which design should take place, as my Lord Sumption said. But there is no need or requirement, and it would be wrong to read the insurer lifetime of 20 years as carrying with it a warranty for every day for 20 years that the structure will stand up. The lifetime requirements to be gained by the design life, which we saw at 326 on page 368, fed into J101, which gives you a calculation.
I mean, does it matter to the issue we're concerned with, on the facts of this case, whether what is warranted is the actual service life of the structure or the design life of the structure? Because given that we know that the problem arose from the fact that the axial loads were underestimated by a factor of 10 because of the error in the value of delta. On the face of it, there would have been a breach of either.
Depends with respect on what the obligation is.
Yes.
There may have been no breach if the obligation is not to achieve a life of 20 years.
I see that, but assuming that there is an obligation, so assuming that the obligation may be described in one or other of two ways, an obligation as to the design life or an obligation as to the actual service life, on the facts of this case, there would be a breach of that obligation, whichever way it was described.
No, with respect.
Why is that so?
So taking the design life, first of all,
Yes.
and the obligation, if the obligation is to achieve a design life in accordance with the code, so using J101 as it is, then if you achieve a nominal annual probability of failure within the code, you've satisfied that obligation, subject to due skill and care.
That begs the whole question at issue, doesn't it? Because for that purpose, you're assuming that the only relevant obligation was to comply with J101. And the whole question we're concerned with is whether that is so.
But with respect, wouldn't the same criticism be made of the way your lordship put the question to me? In this way, I don't mean to be cheeky, but the question is, does this, these words here, require a lifetime of life, in which case, well, of 20 years, in which case the structure's failed. They failed within the lifetime.
Yes.
If, on the other hand, read properly, the obligation was to produce something compliant with J101, and there wasn't the risk of J101 being wrong, then there wouldn't be a breach.
Well, if the obligation is to have a design life of 20 years and to comply with J101, then you're in the double obligation area, are you not? But you are saying, basically, as I understand it, and please tell me if I've misunderstood you, that the design life requirements of the contract are no more than to comply with J101, because you've got to read the concept of design life as meaning design life as specified in J101. Now, I can see that that is the answer that you need in order to succeed, but why is it right? Simply because J101 does operate in that way.
Well, can I turn it around only to this extent, because I think we're probably saying, with respect, very similar things, but at different ends of the same tunnel. The question is the warranty that's identified. It would be possible to imagine a warranty, whatever J101 said and however it worked, that it would last for a period of time. And that's a perfectly possible contract that one could have.
Well, that's what's said against you, effectively, by virtue of the fitness for purpose.
Indeed, but particularly by virtue of the design of the foundation shall ensure a lifetime of 20 years.
That's right. Those are said to... I mean, my Lord's case would involve the proposition, wouldn't it, that the appellants could have relied on all the other provisions relating to design, which they explicitly don't rely on.
Yes, yeah.
They pick out two as critical to link with the fitness.
Indeed, but pausing, not wanting to interrupt you, but trying to deal with my Lord Sumption's point as best as I can. In deciding whether or not the words design of the foundation shall ensure a lifetime of 20 years impose a warranty, it's in my respectful submission permissible to look at J101 and the scheme of the contract to try and decide what's being said by it. If read in its proper context, as I say, and there's an additional point to come back to in a minute, we haven't got to the end of that, but J101 plus the context here plus the other point that I'm coming on to, it is the case that that is not to be construed as a warranty, then we say the obligation is, as the Court of Appeal found, simply to design in accordance with J101. And there isn't any other warranty relied upon as to the correctness of the specification. So in, for example, the Canadian cases, it was found that there was an express warranty that applied. Now, if this isn't it, there isn't anything else, as I understand it. There's the corresponding provision in relation to...
Well, there are also, presumably all the other design obligations to design, etc., might apply in circumstances outside J101, but...
or there could be negligence in complying with... But all of those have gone. All of those have gone. And so, as I understand it, the way that it's put is simply that those words imply a warranty, and it's put by my late friend as a transfer of the risk of failure for the entirety of the 20 years. So if at any time in 20 years the structure fails, by virtue of the second paragraph of 3.2.2.2, it is said that MTH is liable. And that's, we say, is very surprising in the light of the J101 position, which I've kind of stopped. The second paragraph in its context and the other paragraphs, but also trying now to look at the words. The third point I said I'd come back to, it says ensure a lifetime of 20 years in every aspect. So that would be an incredibly wide warranty if it's in every aspect. It would presumably could deal with the issues about the optimization of the design by the turbine tower contractor. It would deal with the failure of other parts. It would certainly deal with all extreme weather events, because as read, it would be to ensure a lifetime of 20 years in every aspect. And if one looks at what was said in, for example, IBA in the Court of Appeal and by Lord Edmund Davis in the House of Lords, one of the difficulties, that's in the context of implied obligation, one of the difficulties that one has is trying to make sense of a lifetime obligation. Now, what one could do is, as my Lord Newberger put to my learned friend earlier, is say that it's an obligation that's breached at the outset. It was breached at the moment when it was...
Well, that's essentially the point that I'm seeking to explore with you.
Yes.
I mean, and I'm not sure why, if there was such an obligation. I do understand that you say there was not. But if there was, it would seem to me to have been broken on the facts of this case just as surely as a warranty about the actual life.
Well, with respect, I'm not sure that's quite right. Leaving aside whether that's the case that's put, I understand it's an alternative case that you were exploring. The first problem would be in defining what the obligation for fitness was if it's not a warranty for the full period and breached on the occurrence of the event, of the failure. So for example, in IBA, it was said to be an obligation that the Met mast would be fit for normal weather conditions, say. And in the Australian case, Stiff and Barton, it was said that the bricks would be fit for normal use without saline water. It's quite difficult with respect where there's an express clause such as this, to try and start implying terms as that. And secondly, there's a problem of identifying breach of that at an early stage. So at the end of a completion of a normal contract, you will have certificates saying that you're in compliance with J101.
You won't have any for this notional breach.
In this case, you did have, of course, certificates. When you say this notional breach, my lord, I'm not sure what you're...
Well, if you're wrong, and this clause has the effect for which Mr. Marin argues.
Yes. But if the clause were an express warranty that it would last for 20 years...
It would mean that the defects liability period did cover a 1 in 50 chance which emerged in the first 24 months.
Sorry, it would mean that...
Yes.
Well, the defects liability period applies where there's a defect in or damage to any part of the works arising from works not being fit for purpose. Well, on Mr. Marin's argument, if they fail within 20 years, they're by definition not fit for the purpose. And so if that's due for a hurricane in the first 24 months, then you have to rebuild it. Whereas one would assume normally the 1 in 50 years is designed to throw the risks of hurricanes on the insurers of the rig owner.
So there's the fourth. I mean, in some way I'm moving between different submissions, in fact I'll draw them together at the end. The other way of looking at this is in the context of the contract as a whole and the contractual scheme, part of which is the defect liability provisions, exactly the way my lord puts it. Part of it also, though, is the transfer of risk provision, which I don't think we looked at. So clause 38(1) at page 301.
Can I, before you go to that, just ask one piece of information? Is the turbine contractor a subcontractor?
I'm sorry, I didn't...
Is the turbine contractor a subcontractor?
I'm sorry, so there was a bang behind me. I'm sorry, my lord. Is the
turbine contractor a subcontractor?
No, he's separately employed. The way that it was procured was what they call a balance of plant. So everything above the flange level was done by a separate contractor.
Understood.
What they call, I think, a balance of plant contract. So everything else.
Do you want to look at 38(1)?
I was going to look at 38(1). Can I?
Where do we find that?
It's in the conditions. So if
Which page? Yes.
It's in bundle I.
Yep. Oh, I see.
And it's at page 301.
301, yep, thank you. Yeah, we haven't looked at this, you're right. Yep.
And what one finds in 38.1 is the contractor is responsible for care of the works until the risk transfer date in 38.2. The risk transfer date is the earliest of the section of works completion certificate issued pursuant to 28.9.1. That's at page 288. And if one just goes to 288, 287, 288, just to see that keeping a finger in where we are, you can see on the left-hand side, 28.5.2 on 287.
Sorry, which page?
I'm sorry, 287, my lord. On the left-hand side, 287, 28.5.2, you see the sections of the works identified, essentially waves of turbines, 15 at each. And the reason for that is, of course, that once 15 are handed over, then the tower contractor can start fixing the upper bits of the tower. So there are different sections with different numbers of wind turbine generators to be attached to them. And then on 288, 28.9.1, there's a section of the work certification.
Yes, I see.
The engineer shall certify on each section of the works has duly passed the tests on completion. So if one goes back now to 301,
Yes.
38.2, the risk transfer date means the earliest of the date of sectional works, completion certificate, or termination. So we're obviously not concerned about that. There is, as ever with this contract, I'm afraid, a little glitch in that, because the risk transfer date is also the subject matter of a definition at 239, which is inconsistent with the provisions that I've just shown you. Almost every bit of this contract is inconsistent somewhere or other with another bit.
You threw in your toes, right?
239, in the middle of the page, you have the risk transfer date, which is the earliest of either the date of issue of the taking over certificate or the date when the agreement is terminated. Taking over certificate is at 289.
Two eight nine.
289, paragraph or clause 29.1. Taking over is when all sections of the works have been completed.
Yes.
So not section by section, but when all sections have been completed. But subject to that inconsistency as to whether risk passes section by section, which we say it probably does, or whether it passes at the end. What 38 is doing is transferring the risk to the owner back at 301 on an event, either on the completion section by section when the next person's going to come and fit on the turbine towers, or at the end of everything. And in paragraph, clause 39.1,
Yes.
page 301, the risk of loss or damage to the works or any part thereof shall pass from the contractor to the employer on the risk transfer date. And 39.3, after the risk transfer date, the contractor's liability in respect of loss or damage to any part of the works shall, except in the case of misconduct, contractor's misconduct, be limited to the fulfilment of the contractor's obligations under clause 29.4, which isn't immediately comparable, or clause 30, which is in respect of defects or damage under this agreement. Clause 30 is the defect liability provision.
Right.
So, again, what one finds is, I think it was the point that my Lord Mance was putting to my learned friend this morning, that one has a scheme which says that after a date of time, you're taken back to the defect liability provision in relation to risk. And yet, my learned friend would say that on the proper construction of 3.2.2.2, any risk that occurs within 20 years would be our responsibility and we'd be liable for it. And that seems an odd way to put the two together. The second point is the point which we've probably been through, but is important just to summarise the defects liability clause provisions. That, as we know from what we saw this morning, is triggered by the appearance of a defect. Perhaps if we just flag the clauses as we go at page 290.
290.
290 in the same bundle.
Yep.
My learned friend took you through bits of this, so I intend to read bits.
Yes.
But if one looks at 30.3,
Yes.
or perhaps if one Yes, one looks at 30.3 first of all. Any such defect appears or damage occurs.
Yes,
That's essentially the trigger with the notification.
yes.
That's why it would become patent. And then 30.1, save as extended under 30.4, which is the passage of the contract we looked at this morning. There's a 24-month period for defect liabilities.
Yes.
And then there's the making good obligation you saw under 30.2. And then that goes to 30.10, at 292, and that leads into the certification procedure. So at the end of the fully fulfilling of the obligations, there's a certificate that leads to the payment certificate, and so on. And we've seen that scheme before. Now, if one looks at the options here, as the way that it works, on the face of it, in 30.4, 291, there is a 48-month cap on liability for all defects.
Yes.
And that sits, as my Lord Mance was saying, with the gap between the defect liability period and the certification and the 4 years as a long stop. As I understood what my Lord Neuberger said this morning, he said, well, hold on a second. So, well, perhaps 30.4 is not to be read that way because it's to do with an extension of the defect liability period. And perhaps it's only to do with the extension. So we say that's wrong. But if that were right, one still has the entire agreements, or the remedies clause, exclusive remedies clause,
Yes.
at 303.
Yes.
Yes, it's no skin off your nose because
There's no other remedy
there
available.
isn't anything else.
You say the closing words of
Yeah.
42.3 couldn't be wider.
Exactly. No, but let's assume that I'm wrong about that. And in some way you can get round the remedies to get a claim for damages beyond 4 years for a latent defect. Then now there's a limitation issue, because this is a contract not under seal, so that a defect that became patent would only be 6 years from, say, taking over, being the last date for breach in any event. So the scheme that one finds, the scheme that one finds here, the scheme that one finds here is common in a number of contracts of this sort, where there's a detailed series of provisions for remedying defects within time periods, and an intention that everything else is ruled out from then on. So you've got a risk transfer provision at either the sexual completion or taking over, with a detailed, referring you to the defect liability, with a detailed scheme beyond that, none of which really works in any way with a warranty that lasts or endures essentially for 20 years. If one compares that with what I understand would be the effect of my learned friend's submission, presumably one would be entitled to bring claims for damages, he would say, as latent defects, for some 26 years after taking over. To get there, you'd have to get through all the questions of the 4 years and the exclusive remedies and so on, those problems. But beyond that, you'd have to say that a failure, say, due to the weather or whatever in year 19, was the occurrence of a latent defect. It's a slightly odd sense to say that it's a defect because of the failure, because of weather. It's not really a defect at all, it's an event. As Mr. Marin put it, frankly, the effect, he says, of 3222 is the transfer of a residual risk to the contractor. So it's the occurrence of a risk. It's not really a defect in the sense of a non-compliance. Neither in any sense is it latent, in the sense of something that didn't occur before the contract, but was there, before the taking over, but was there. So with respect, no one but a lawyer would really think that the way through this was to say, well, of course, if it blows over in year 15 or year 19, we've got a claim under 322, which we can pursue because it's a latent defect in this way. And then if one stands back and says, well, what's said by E.ON is that this is important commercial protection that is valuable to the owner because it enables them to sue or to sell the project. The way the industry works is, of course, they might continue to own it, but there's a secondary market in these things. It's an income stream. And if one said to oneself as a potential purchaser of this scheme, how are we protected in the event of a failure in year 19? It hardly springs off the page to say that it's 322 plus the provisions that we've gone through. And with that, perhaps I can come to this extent full circle. Before we took a little detour, well, quite a big detour, we were looking at J101. And my lord said, well, why were we looking at J101? I won't go back to the details of J101 because we've understood that it's a probabilistic scheme that comes up with a nominal risk of failure, nominal annual risk of failure. And this is our case in paragraphs 15 and 16. So at core page 133, 134.
Yes.
Where we set out what we submit are the benefits of the J101 type provision, that is a standard. And that is why, in our submission, people use a standard. One finds this in the introductory words of J101 right at the beginning. But the sort of scheme that we started going through with the nominal annual probability failure is a result of years of research and development, as set out by Ms. Feld.
I see that's the advantage, but in the end, does it help on deciding if there's something wrong with the J101 standard, who bears the consequences?
No, not on its own. But in context, it might, because if one says that you've got two possibilities, you're assuming there are just the two and parking the earlier breach, which I don't think is part of the case, but the earlier breach. On the one hand, you say, is this a warranty for life? Because on the point that we're on, it's commercially attractive to be able to say that we have a safeguard if the plant fails in year 20. We have a right to claim damages. On the other hand, you say, well, actually, look at this in this way. It's more like almost a sale by documents. If you have a certified wind farm in accordance with J101, that's recognisable and acceptable by all stakeholders. And for these reasons, the 8 reasons that are set out in paragraphs 15 and 16, there's a real advantage in having a scheme which is in accordance with J101. And there's no need for the additional warranty.
If one asks, I suppose, in general terms, whose business is it? And it's the rig owners are the people who initiate this.
Yes.
And take on general risks. They want it built according to J101. You say that's at their risk.
Yes. Absent a clear warranty, which takes us back into our discussion of what the warranty means. So can I try and put the point I was just making, which links up with what my Lord Mans put, rather philosophically or melodramatically in this way? In a way, the fight between the two sides is this. There is the traditional approach, which you could call almost determinism or Newtonianism, which is that A causes B and you can always do something. And if you're building a medieval cathedral, what you do is you put up an enormous flying buttress to hold it up. You don't design it or calculate it. And if it starts falling down, you make it a bit bigger. That's the traditional way of building, because you didn't have things that could be calculated. They'll last for hundreds of years. It's not a very efficient way of doing it. The alternative, as it were, the post-Newtonian world, is a probabilistic, almost a quantum type approach. Well, what you do is you model the probabilities and the outcomes. There, you accept that you might not have certainty, but you are gaining an optimized integrated solution with a risk attached. But the risk is understood because it's in accordance with identified safety classes and in accordance with rules and in accordance with a body of knowledge. And what we say is what was asked for and what was provided is the second here. And there's no warranty that complying with the standard had to be right. It's not said there is one. And there's no general warranty of lifetime, because that isn't what 322 says.
Well, that's the question.
But that, if one was to put it at the starkest, is almost the philosophical thing. And it's quite... It won't arise in this case, but it may arise for your lordships in the future. More and more contracts are being designed in this way. Roads, you don't just build thick roads, you work out how thick you need them to be for a particular use. Computers, they don't work all the time. They work some of the time. We accept a level of fault, a level of failure. And what we say is that this is an intelligent design that was performed in accordance with precisely what was required. There's no complaint now, no complaint made about the way it was designed. But it contained within it a residual risk of failure. And that residual risk of failure was not transferred to us. And we come to the proxy case, as I put it, which is to say that that residual risk of failure in year 20 not being transferred, there isn't a warranty on its own which says that we have taken the risk of the standard not being there. Putting it very crudely, they asked for a design in accordance with J101, and that's precisely what they got. My Lords, I think I've gone a little bit out of order, but I've just checked with Mr. Channels, who knows everything there is to know about everything. I think I probably covered all the points that I was going to cover, rather quicker than I thought, and in a different order.
Well,
but unless I can assist your
apologise for any
lordships.
of that, it's very welcome. If you just want to check that you have covered everything, please feel free. Wouldn't want you to be disadvantaged by having been speedy. Anything you want to ask?
No, I don't.
There are perhaps 3 points. Thank you for that.
No, not at all.
Perhaps 3 points that I should deal with merely by way of 2 points, I think. 3 points that we deal just by way of sweeping up. They're these. My learned friend places some reliance on TR 10.24.9, his new provision,
Yes.
which is at 549.
Sorry, what page?
Sorry, it's in I9
Yeah.
at page 549, so almost it's right at the back, just before tab I10.
Yes.
Thank you.
The Lordships recollect in the case for E.ON, they said there's an additional provision they wanted to identify, and it was this to do with cathodic protection. And we deal with this in our case, but very briefly, what this is dealing with is the testing. One goes back to page 546, 1024.
Yes. That's right.
So this is to do with testing, and this is to do with equipotential testing of the cathodic protection system, as one sees in the end of the second line, the beginning of the third line at page 549. And this is the testing of the designed cathodic protection system to see whether it will continue to operate during the period of life. And with respect, it doesn't take debate any further to be testing a system to see whether it will last. In other words, whether the currents that are being generated will be sufficient to ensure the adequacy of the cathodic protection and that you don't use the anode material fully by the date upon which 20 years elapses. Secondly, this touches the point my Lord Sumption was making to me, that a point is made about the difference here between a design life and a service life. And the point, by way of answer, is that if one looks at the references, both in J101 and the technical requirements, one finds the terms both design life and service life being used effectively interchangeably. So perhaps if I just give you the reference now rather than go to it. Mr. Marin showed you page 820 of J101, where it's a question of the design being based on the service life.
Yes, he did.
But if one looks at page 808, so just a little bit earlier, essentially. And then finally, what I think was an entirely new point that my learned friend made relating to MetOcean data. He drew attention to the fact that MetOcean data was provided by the employer and was the subject of certification by DNV. And with respect, again, it's a short point. There is a need for data in producing the design. The data was provided on a long-term basis by the employer, but there's no warranty that will only be that will be the only weather that's ever produced, which is I think what my learned friend was suggesting. Indeed, that's the whole purpose of modelling the weather and taking, for example, the 98% quantile for the ULS.
Yes.
And that question about the Met Ocean data really goes nowhere. We're back to 3.2.2. So I think subject to those three sweeping up points, which are quite small.
The judge, I think, I'm not at all sure because it's a little obscure, the judge appears to have equated the obligation to ensure that the foundations will have a service life of 20 years with an obligation at the outset to design it so that that happens. So he doesn't seem to have made the distinction that you have been making in your submission between these two obligations. I mean, I'm looking at paragraph 78 of the judge's judgment.
Yes,
where he makes the point that because the service life has to be at least 20 years, that is perfectly consistent with an obligation to design it so that it will have a service life, because you don't have to get it spot on.
If one reads on, your Lordship probably has read on into paragraph 79, because in paragraph 78 he was dealing with a submission of mine, which he said was more focused, and he deals with the word minimum.
Yes.
And then
He was dealing, as I understand it, with your submission, that there was a natural inconsistency between these two kinds of obligation, and he is suggesting, I think, that there was not.
He was saying that you should, he found against me, didn't he? He was saying that you could read the two together. If one goes on to
Yes.
paragraph 79, he says at the top of the page, on page 208, that an employer would hope and expect the turbine so designed and constructed would not only operate satisfactorily, would also last for its design life. And that's essentially the Court of Appeal's finding. But he, the judge, went on and say that the employer could, if he wished, stipulate also for a term that the turbine should achieve a particular service life. That's my learned friend, Mr. Marin's case. And paragraph 80, about 3 lines from the bottom, having considered the submissions and the authorities, says that in my judgment, MTH warranted the foundations would have a service life of 20 years. So I think, if I've understood my Lord's question, he understands that there's a distinction, accepts there's a notional distinction between a design life and a service life, but finds, on the words of clause 3222, that there was a warranty of a 20-year lifetime, ensure a lifetime of 20 years in all respects. I think that's the way the judge's reasoning worked. And then, obviously, in the Court of Appeal, Lord Justice Jackson, if one goes to page 176, paragraph 104, he's been dealing with the various contract clauses and then talks about a reasonable person in the position of E.ON and MTH, knowing that the normal standard required was compliance with J101 and that such compliance was expected but not absolutely guaranteed to produce a life of 20 years. If one adopts an iterative approach to the construction of paragraph 3222 and 3B51, it does not make good sense to regard them as overriding all other provisions. But another way, there's an inconsistency. And then in paragraph 105, we're pressing Mr. Marin about what could have been done, and 106, Lord Justice Jackson comes to a conclusion, saying that paragraphs 3222, 3B51 are inconsistent. They're too slender a thread upon which to hang a finding that MTH gave a warranty of 20 years' life for the foundations.
Reading that, you might say that Lord Justice Jackson said there were two options. One was to give those two clauses no meaning and effectively reject them as being inconsistent with the contract, as he saw it. And the other was to give them the meaning for which Mr. Marin argued. And as a simple point, it could be said that if your choice is between giving it a meaning that you accept it could have, or rejecting whole clauses or subclauses, it's a rather extreme thing to reject a clause or a subclause as meaningless or inconsistent, and you should grasp the nettle and accept they have the effect that you may not like, but that you're giving them effect.
Which is why one of my submissions in terms of construction was to say, look at that paragraph, the second paragraph of 3222, with the ones before and after in the context of plan maintenance. As I say, that all that is, in terms of the detailed design basis, is giving effect to the requirement that there shouldn't be plan maintenance within the lifetime.
That's what I was going on to put to you, that you're not entirely supporting what Lord Justice Jackson says. You say there isn't an inconsistency on your interpretation, and therefore there isn't a rejection of the clause. It just has a different effect from that which...
I want to have my cake and eat it, obviously. Can I put it this way?
One can always try.
I can try, yes. Made the same point to Lord Justice Jackson, and he's reached these conclusions in this way, without reference to them. So that's slightly different, because I say that you can reconcile the two in the way that I've suggested.
That's I'm putting to you. I mean, nothing wrong in you
No.
seeking to uphold the decision below on slightly different grounds. But what I'm putting to you is that they are slightly different.
However, that part of the argument is not there. It was there in the Court of Appeal, and
Right.
it wasn't the way. However, I do still stand by what was said. I said to the judge, and I said to the Court of Appeal, that one has to construe these. It's the iterative approach by testing them. And this provision, if construed in the way that's suggested, is inconsistent with J101, all the other things. So it's not as though Lord Justice Jackson decides it on an entirely different basis.
I'm not criticising your Lord Justice Jackson. I'm just trying to see that I've got the point. I think I have, that your submissions are slightly different from the way that Lord Justice... Nothing wrong with that.
No, but I think we're probably violently agreeing, but I put an additional point that Lord Justice Jackson didn't accept. However, I still take the point that the two are inconsistent, and that's a reason for construing as well.
If you look at the second sentence of each of the two specific provisions, 3.2.2.22 and 3B51, in the same language, it does focus on the original design choice. It says the choice of structure, materials, corrosion protection system, operation and inspection programme should be made accordingly. And I think you can not only say that that focuses on the original design choice, throwing some light on what the first sentence is doing, but it also focuses on the question of maintenance and plan replacement.
Yes, absolutely. So perhaps
you've got to get that right. It's got to be designed for in structure, materials, corrosion protection, etc., etc.
So in terms of the construction, there is in the context of this, what it's dealing with, they're instructions, and the natural way of reading in the context of the rest of the contract, these are instructions as to how to design. And the second sentence reinforces that this is about plan place. This is what you've got to do. There's a second constructual point or textual point within 322, which is that in the first paragraph, one is dealing with J101, and it's odd to find the second paragraph saying something different. There's a third point that the second paragraph is, as Mr. Marin puts it, the transferring of a risk, this is not where you would expect to find it. It's not a point, as Mr. Marin puts it, being tucked away. This is saying, effectively, despite the first paragraph, we're going to transfer the risk. And then there are all the points about the contract. And we say, as Lord Justice Jackson accepted, but in a slightly different way, if one looks at the various provisions and goes back and forth between them iteratively, it is wrong to construe the second paragraph in the way sense contended for by E.ON. And if that warranty doesn't exist, there isn't a warranty that assists E.ON in this case.
But you and Lord Justice Jackson both accept that sort of dual contractual liability type contracts do exist. I will build in accordance with this design,
yes, I mean,
but I will also be liable if the design doesn't work, i.e. I may have to build in accordance with this design plus, as it were, if there's anything wrong with this design so it doesn't comply with implied terms or express terms.
For my part, and I appreciate the term came from Lord Justice Jackson, so I'd be slow to disagree with him, but I'm not certain that the dual obligation moniker is particularly useful. You often have clauses which have, so in a design and build type contract, you may or may not have fitness to purpose, but you'll probably have strict requirements in relation to quality of materials, workmanship and various things, and you might have a design. So there may be all sorts of different interrelating obligations.
But
so the question is just to construe them.
If you've got a fitness for purpose, and you've got a design in accordance with specific requirements, the specific requirements don't result in a fit for purpose, something has to give. And to that extent, the two clauses can be said to be by definition always inconsistent. And the way one would make sense of them, I would have thought, was to say that you have to build in accordance with the specific design, but insofar as the design falls short of fitness for purpose, you have to, as it were, up the game.
So the question becomes whether, particularly 3222, has that effect.
Exactly.
Which is why that was going to be the first thing I said, but it was before lunch, and also I thought we'd better go to the technical sides. There's a really, I don't think there's any particular material difference between 3222 and the other B. I always get the number wrong. 3B51.
Helpfully set out on
Yeah.
Mr. Marin's skeleton.
So the short point of construction is whether one calls it the purpose or whether one calls it a warranty is how one reads the second paragraph of 3222.
I see.
And that really gets back into the same discussion that we had before.
In the other types of contract my Lord's referring to, it might, I presume, be of interest to see who has specified the design. In the present case, it seems to be a sort of industry-accepted standard which rig owners would be happy with.
Yes.
And it might be different if a contractor puts forward a design and says, I will also achieve this result, and then he's understandably taking the risk.
Absolutely. I mean, and I mean, the particular risk that occurred here, I think it's fair to say, is one that no one would have thought of, which is named the standard was wrong. But the way that we've been testing it is because of the warranty, ensure a lifetime of 20 years, is to test what would have happened in a failure in the 19th year, because that would be within the warranty. So it's just, does this warranty mean that? By reference to it, if the warranty doesn't mean that, there is no other warranty. It would be possible to have a warranty that said we guarantee the standard is good, or that we guarantee this or that.
Warranty that the design is such that you would expect it to have a service life of 20 years. Unless the warranty is in fact that the design is such that you would expect a service lifetime of 20 years.
But that, I think, goes back to our previous discussion about what J101 does.
Yes, but I mean,
But if there's a warranty
there
that
are
sits
two
beside it.
questions. One is whether that is a permissible alternative reading of the contract. The other is whether it's open to Mr. Marin at all, having regard to the way in which he's previously put the case. Now, I understand your point that he's never put it that way before, and it may be that there would have been a possibility of different investigations if he had. I don't know what the answer to that is.
I was focusing on the first as to why it was not a permissible reading for the reasons that we've rehearsed and I've been through. But
If it is a permissible reading, do you say it's excluded because of the way that it's been put to date?
I didn't understand Mr. Marin even adopted that.
He specifically disclaimed this argument, as I understand it, and that's why the case turns on the combination of the fitness for purpose provision and these two specific provisions. If it turned on the general design obligations, we would have heard a case on it.
Indeed. And I understood the way that it developed was in two parts. I think it was my Lord Newburger said to my learned friend, what about this way of putting it? Your case might be better put this. And he said, I'll think about it. And my Lord Newburger said, I think that's a nonny question. And then a little bit later, in answer, I think, to my Lord Mance, he expressly disclaimed responsibility in relation to the design obligation. So it's not a case that's even being run, as I understand it. There's one other matter perhaps I should just deal with briefly, because it was a point that's in the same context, that is redundancy and losing whole provisions that my learned friend dealt with. It's 30.2 D.
What page?
At page 290 of I3. And this is the making good defects and fit for purpose provision. And perhaps there are two bits we ought to look at. One is that something's obviously gone wrong with this clause and elsewhere in the drafting. So in 30.2D, there's the last line, the last 4 or 5 words says, and defect shall be construed accordingly, with a capital D. That presumably applies to all of A, B, C, and D. And defect should then be used. And just for reference, there's an inconsistency about using the small letter defects and damage
Yes.
and using the capital D defect. And the other provision for fitness
Yes,
is obviously at 8110 at page 260 in the same tab.
yes.
And here,
What page is that?
260.
268.
260.
You say fit for purpose.
This is the
for
fit. The
it-
fit.
Fit for its purpose.
Yes, so this is obviously a different definition. So it would be very peculiar with respect if the parties had intended to be two separate freestanding definitions for fitness for purpose, meaning different things. And
Well, it obviously means, actually, it means precisely the same as the defined
I think it must.
capital. Well, if you look at it, it says fit as determined in accordance with employers' recommendations, tech specs, and that's the definition, isn't it?
Well, I think there's a different mention of good industry practice, but that wasn't actually the point that I was making. You have, in common with other bits of the contract, a less than seamless interaction of provisions and definitions. The point I was getting to was this: that my friend said, "Well, what effect are you giving to 8110?
Yep.
Is the whole clause being treated as one? With respect, that's not right. First of all, 8110 deals with defective workmanship materials. Secondly, it's divided into each item of plant and works. So there's lots of scope for the items of plant to be fit for purpose determined in accordance with the specification. For example, the boat landings might be fit. There are gaps to be filled. As to the works, the approach that we would take to that, if one goes back to the general...
Well, it's fitness for purpose is an additional obligation in addition to freedom from defective workmanship and materials, isn't it?
It is. It is.
Yeah.
Now, I'm sorry, I wasn't suggesting otherwise, but it has to be careful to think which bits might be said to be, in inverted commas, redundant or affected by the redundancy submission. If one then wanted to find out purpose for either the pieces of works or for the whole of the works, the natural starting point in my submission would be the key functional requirements part of the spec at page 354 behind I4.
Right.
B54.
Page 354, my lord, yes. 1.6, we saw key functional
We've got
requirements,
this, yeah.
and we've seen the first three paragraphs a couple of times.
Yes, we have.
But if one looks now at, for example, the bottom paragraph, starting the works elements
Works
provided,
elements,
shall operate under all ambient conditions likely to be encountered at the site. Or the paragraph at the top, starting at the top of 355, components which cannot be designed for a life of 20 years. This is the bit before that, isn't it? Protracted periods, it's the end of the paragraph at the bottom of the previous page. Protracted periods of inoperability of turbines should be accounted for. And then the last paragraph, the extent of supply should be such that no failure of single item of equipment or structural component should result in the direct loss of or affect the performance of critical systems. Now, one can imagine, for example, in relation to the works, that leaving aside failure or lifetime, that the works were not able to operate under all ambient conditions. That could give rise to a claim for fitness for purpose. Or that if they failed, a single item of equipment might result in the direct loss of or affect the performance of critical systems or structural elements. So, to the extent there's a problem, it's a problem because the technical requirements don't stack up with the standard terms. But it's wrong to say that there's nothing. It's just that this term, that's the 3222 term, does not define or warrant the purpose, we say, for the reasons that we've been discussing.
Whereas 1.6 does, you say?
1.6 is where one would look under
Yes,
key
I
functional
see.
requirements. In there, there's a design life of 20 years. We've seen that, the third paragraphs.
You find the odd warranty, you say that?
Yeah, any warranty you'd find from here. I'm not saying you couldn't look at other things as well, but this is where you'd start. And what's conspicuously absent is simply that they shall last. That's found elsewhere. And there are things here that will work, both for the individual items of work and for the work as a whole. So having said probably 20 minutes ago that I was about to stop,
It's only because you've been asked questions, don't worry. Thank you very much.
you could ask some more questions, but subject to that, my lads. Unless I can assist your lordship further.
Lord James, thank you. Marion.
Thank you, my lord, sir. First point, you will have noticed that I think that my learned friend accepts that the foundations in question did not, in fact, achieve a service life of 20 years. That, I think, for some while, but I think it was accepted, if not precisely in terms, very closely in response to my lord's question. My lord, a moment ago, rather shortly, my learned friend did address the question of what the purpose for which the foundations were required might be. Lord, that's very much the heart and starting point of our case. He addressed it in a very short space of time. And, my lords, we submit that it does warrant more time and more attention than he gives it. The starting point, of course, is that we rely upon the conditions, the contractual terms 8, 1, 10 and 32D, which both identify an obligation to achieve fitness for purpose, leaving the purpose to be determined from the specification. And so, my lords, one turns to the specification, and I made the submission that the various provisions which we've summarized in our case, all of them in one way or another serve to identify the purpose. One must bear in mind that these provisions are to be seen through the eyes of Lord Hoffman's reasonable man, who has available to him all the information and understanding which was available to the parties at the time of the contract.
At what point of time?
At the time of the contract, my lord.
Well, yes, but if you're asking yourself whether the works are actually, as constructed, fit for purpose, that, I would have thought, was a question you asked yourself as at the point when the works were complete. You wouldn't ask yourself whether it was fit for purpose in the light, retrospectively, in the light of, for example, it collapsing in the 19th year. There's got to be implicit in the situation at the delivery of the works, has there not, the risk, an excessive risk that it will not last 20 years.
My lords, I'm not on the point of whether or not the structure was compliant with the obligation. I'm on the point whether there was an obligation in the first place.
Well, I know, but I'd quite like to know what that obligation actually means. If you say the relevant purpose was to last 20 years, which I think is your case,
Yes, my lord.
You have to ask yourself, what do you mean by that? Do you mean that the situation at the time when the works are complete has to be such that one would expect it to last 20 years? Or do you mean that you wait for 20 years to pass and see whether it's actually lasted that long? And if it's not, then automatically it must have been unfit for purpose.
Former, my lord.
Right. Well, then one is looking at the prospect, as at the completion of the works, having regard, presumably, because there's nothing else to go on, to the way that the works have been designed.
Yes.
Your case, as recorded in the judge's judgment, and as you confirmed when you were on your feet this morning, is that the warranty of fitness for purpose means it's got to last for 20 years, which seems to be something different.
Lord, yes, it is something different. I don't recall putting the matter in that way specifically. It may be that His Lordship didn't entirely follow the case, or perhaps that point didn't emerge at the trial, but, or indeed it may be that I adopted loose wording during the course of the trial in the submissions. But,
Well, can you formulate, please, with an eye to this temporal question, what you say that the warranty was?
Warranty, Lords, was that the foundations would be designed, installed, and completed so as to be fit for the purpose to be determined or inferred from the specification, alternatively the employer's requirements.
The purpose being?
And the purpose being, my Lord, that they would support the superstructure for a service life of 20 years.
Because the judge seems to have assumed that your argument was different. He seems to have, when summarising what he submitted, what he suggested was the issue, at paragraph 61, whether it imposed a strict obligation to achieve a service life of 20 years or merely an obligation to design the foundations on the basis of a 20-year design life in accordance with J101. Now,
Yes.
Those two possibilities don't exhaust the logical possibilities, but he is clearly assuming that your submission was that there was an obligation to achieve a service life of 20 years and not just to design it so that that could be anticipated.
Yes.
Well, was he right in describing the way that you put your case, and do you still put it that way?
My Lords, at trial, we focused obviously on clause 3222, which in terms does call for ensuring a lifetime of 20 years.
Right.
And
So at the
Lords,
trial, you did put it the way the judge clearly understood you to be
Yes.
putting it.
that being said, my Lords, I recall that at the trial, my argument, I think, matched the argument which I presented to your Lordships, that I rely primarily on the conditions of contract as a warranting fitness for purpose, the purpose to be identified from the technical specification. My Lords, my learned friend, when he was addressing you, made the point that the appellants rely just on the two clauses, 3222 and 3B51. My Lords, when I was addressing you this morning, I sought to show that the matter goes a little bit further than that. You will recall that if I refer to the provisions set out on page 109 of our case, that's E.ON 109, at paragraph 31, I sought to divide the series of 7 clauses into 2 groups, the ensure wording and the design life wording. And, Lords, I did indeed present the argument that the purpose is expressly evident from the ensure wording. But, my Lords, you'll also remember that I drew attention to the design life wording and made the point that the required purpose is implicit in the design life wording. I took as my example the first of the extracts which you find. It's T 1.63, and of course that refers expressly to a design life of 20 years. And I pointed out that J101 shows that, ordinarily speaking, a design life is to be based on a service life. And in those circumstances, my Lords, I submitted that the use of the expression design life of 20 years itself implied a service life of 20 years. And, my lords, I pointed out that that was implicit in respect of T 1.63, and then I drew your lordship's attention to the other design life wording, some of which made the purpose not simply implicit but explicit. And, my lord, my example of that was the third of the three extracts, T 3.2.6, which, albeit is design life wording, because that is what the clause is directed to, it nevertheless refers to a minimum service life of 20 years. My lords, I made the point that that applies not only to T 3.2.6, but also over the page to TR 3B56, refers to a minimum service life of 20 years. And I submitted that it was also true of 10.24.9, the last of the seven, law which refers to an operational 20-year life. And so, my lords, so far as the purpose is to be discerned or inferred from the technical requirements, I rely upon all of those provisions, including the design life wording. It is not my case that the purpose is to be found exclusively from TR 3222 or TR 3B51, the ensure wording. And my lords, I return to the point that I was seeking to make a short while ago, which is that these various provisions are to be seen through the eyes of Lord Hoffman's reasonable man. And he will know, my lords, a good deal, I submit, about the kinds of document that he is looking at and interpreting. He will be familiar with the drafting technique, which I mentioned at the outset of my submissions, where the requirement for fitness for purpose is set out in the conditions of contract, with the purpose to be identified from another document. And he will be familiar with the idea, therefore, that in the case of a modern design such as this, which incorporates J101, there will, on the one hand, be obligations which require the contractor to design in a particular way, and as in this case, on a probabilistic basis, leaving some risk in any one year the structure might fail if extreme conditions were encountered. Whilst, on the other hand, imposing on the contractor an obligation in the nature of a warranty or guarantee. We have, in this case, obligations as to fitness for purpose, which are not expressed in terms of warranty, but they are in substance, my lords, the same as in other cases, including the Canadian cases to which we have referred. And, my lords, so far as prominence is concerned, can I draw your attention to this aspect of the points I've just been making? If you look at the first of the 7 extracts to which we refer, yes. It's TR 1.63. My lords, that refers expressly to design life, and I submitted that has implicit in it the requirement of a service life of 20 years. My lords, that comes from the key functional requirements. You see, we've noted that in the subheading, and the reference in the documents is one that you've seen a couple of times today already. It's I-5 354. And so when my learned friend submits that the identification of the purpose is not where you might expect it to be, Lords, my answer is, well, it is implicit in text which is to be found in the very place to which he refers, the key functional requirements. My Lords, a number of times my learned friend referred to the appellant's case, suggesting that the transfer of risk is to be found at the clause which we've called 32222. My Lords, my case, of course, is that the transfer of risk is to be found in the conditions of contract, where the obligations as to fitness for purpose are initially specified. That's 8110 and 32D. Lord, the next point is a point about redundancy. My Lord,
It's interesting to look at 8110. We're focusing on 4 words, but maybe it's better to, also quite helpful to look at the whole thing.
Yes.
So that each item of plant in the works as a whole shall be free from defective workmanship and materials and fit for its purpose, as determined in accordance with the specification.
Yes.
Using good industry practice. I imagine that as determined in accordance with the specification governs all the previous concepts, defective workmanship and materials and fit for its purpose, as determined in accordance with. So you look at it and ask, it might be said that the fundamental requirement is that you jolly well got to comply with the employer's requirements.
Well, my Lords, the anterior obligations are that the plant and the work shall be free from defective workmanship and materials. Lord,
Yes, but in accordance with the specification probably governs that, doesn't it?
my Lords, I would grant that that's a possible view. I would submit, however, that more likely the words in question, as determined in accordance with the specification, are really related to the reference to fitness for purpose.
Why? Why wouldn't they want to define what they mean by workmanship and materials, and don't the employer's requirements do that?
Yes, my Lord, it's
What the judge held about this was that good industry practice was simply a mode of identifying what the relevant purpose was.
yes, that was my submission at the trial. But, my Lords, my point in respect of this provision and 32D related to redundancy.
Sorry,
my
Lord
Lord,
Marion, sorry.
my Lords, my learned friend's construction of the contract would, we suggest, make the words fit for its purpose, at least, redundant in 8110. And similarly, my Lords, in 32D, which is at page 290,
Yes,
it would
that about also, yes.
similarly make wording redundant.
Well, it wouldn't be redundant. I mean, obviously, a good example was given in relation to plant, wasn't there? I mean, one can think of lots of things which could be not fit for their purpose.
My Lord, yes, one could probably think of some. None have been suggested in this litigation until within the last hour. But, my Lords, there we are. So far as the employer is concerned, he's interested in the fitness for purpose obligation, which really assists him. And, my Lord, in our submission, when one looks at the technical requirements, it's very obvious that the purpose, which is expressed and implied in the provisions to which I've referred, is that the foundations should continue to support the superstructure for a period of 20 years.
Yeah.
And, my Lord, we say that's simply not inconsistent with the modern design principles, because this was intended, we submit, to be a contract of double obligation. And that's the point, my Lord, that we make at paragraph 15 of our case, Lord, that's E1 105, where we make the point that the residual risks which result from a J101 design are allocated by the provisions to which we're referring to the contractor.
I understand that.
My Lords, the other point I need to address is the matter of latent defect and the various provisions relating to the defects liability regime, the transfer of risk regime, and the final certificate regime. My Lords, it may be convenient to start with the exclusive remedies provision itself. It's clause 42.3 on page 303.
Yes.
And my Lords, my starting point for these submissions is this. In a contract such as this, ordinarily one would expect an employer to have potentially a remedy in damages for breaches of contract giving rise to defects, whether they were patent defects or latent defects. Lords, of course, there are cases in which the right to such a remedy is given up, but, my Lords, clear words are required. That's Lord Diplock in Modern Engineering and Gilbert Ash and elsewhere. If one then looks at 42.3, one sees that the way in which the clause works in the second paragraph is to bite upon the remedies provided under the agreement. And Lord, the consideration for your Lordships is whether remedies are provided under the agreement in respect of latent defects. Because, my Lords, when we come to look at the various provisions to which your attention has been drawn, it seems that there is none of them which actually provides a remedy in respect of latent defects. There's a sense in which one can take the defect liability provisions fairly quickly. Obviously, you can't give notice to a contractor to come back and repair work unless you know about it, unless the defect is patent. My Lord, the way in which the 4-year long stop works, we submit is as follows. Looking at 30.4, this is page 290 of tab I5 at the foot of the page. The extension applies in this way. There are 3 paragraphs at the top of page 291, which I've mentally numbered 1, 2, and 3. As regards 1, there is an extension of the defects liability period in respect of work of replacement and renewal, which is customary and readily understood.
Yep.
And obviously applies to defects which have been patent and have been repaired, and a further defect potentially capable of being remedied. Then, my Lords, the second provision relates to something rather different. It's another means of extending, at least in part, the defect's liability period. It relates to a defect which have the result that parts of the works cannot be fully used. And again, my Lord, that relates to patent defects, not latent defects.
Why? Well, I mean, obviously it relates to defects which have become patent, but why shouldn't it apply to things which were originally latent?
Well, my Lord, that I accept. That there are patent defects which may have earlier in time been patent. But, my lords, I'm concerned with latent defects and what remedies are given. And so far as this particular regime is concerned, neither of those two provisions relate to works which remain latent. The third provision, my lord, paragraph 3, is the long stop. My lord, our submission is that that long stop applies to the extended periods which may or may not result from the prior two paragraphs.
Yep.
To construe it as a limitation in general of liability for defects would be an unusual approach given its placement in the contract and given the point that I made earlier, that if a party is to be taken to have given up a remedy, clear words are required.
Well, in relation to defects in the corrosion-resistant coating, if they don't become patent, they're obviously barred after 5 years, aren't they?
Yes, my lord,
So why shouldn't other defects which don't become patent not be barred after 4 years?
yes. My lords, I don't have the reference for...
Well, it's page 344 is dealing with the
I'm grateful.
Schedule 1.15,
Grateful.
E 1.15 in Schedule E.
Yes.
I mean, it doesn't mean anything if it doesn't apply to latent defects.
Well, my lords, the provision in respect of these coatings is the same as the remainder of the defects liability regime, namely that it applies only to defects which have become patent.
I see, so it doesn't mean anything. If they become patent within 5 years, you're covered. If they don't become patent within 5 years, they're latent and you're covered.
Well, my lord, the difference is between two different kinds of remedy. The defects liability period gives the employer a remedy in repair, that's to say, the right to have the contractor come back and undertake the repair. The remedy in respect of latent defects is a remedy in respect of damages, my lord.
Well, again, you have the problem that
What about 42.3?
it's, all damages remedies are excluded.
What about 42.3 then on page 303?
Well, yes, my lord. The point is that no remedy is provided in respect of latent defects.
Well, we're going round in circles.
No, but it talks about the exclusion of any other remedy that either may have against the other under the law governing this agreement or otherwise. Couldn't be wider.
Well, my lord, it is wide, but it can only refer to the categories of breach that it is directed towards. And when we see the remedies which are provided in the agreement, particularly the defects liability period, the remedies there are also all of them directed to patent rather than latent defects. My lords, my submission is reinforced by the terms of the final certificate provision, which, of course, as you'll recall, carves out latent defects as a remedy which remains open to the employer even after the issue of the final certificate for payment.
In this particular case, your claim is based on what? Is it a claim for damages or is it a claim under the defects liability provision?
My lord, it's both of those.
It's both of those,
Yes.
Am I right in saying that if it's the latter, then the time limitations don't bite in this particular case?
That is right,
Yes,
my lord.
but you're praying these provisions, you're explaining these provisions in aid of your construction of what the warranty is.
Precisely, my lord.
Rather than saying that the limitation in any way bites on you.
Exactly right.
Yes, thank you.
My lord, notice of defects was given prior to the expiry of the defects.
Yes,
liability.
It's all right.
Yeah, but we're seeing how it works.
Of course, I have to deal with this because it shows how the warranty, for which I
Right.
contend, is not inconsistent.
But if the warranty applies as at the date of completion, then the limitations in the contract, if they are against you, could still operate quite consistently with that warranty, that you would have a warranty as to fitness for purpose, but you'd have a limited time in which latent defects could become patent.
My Lords, the warranty, as I submitted earlier, is one which has to be fulfilled as at the date on which the work is complete.
Yes.
But the remedy in respect of that would not be sought or claimed until the breach had become apparent.
Yes.
And Lord, in this case, it did actually become apparent very early on because
Yes.
the structures failed.
But I'm just saying there is a possibility of a warranty with only a limited time in which it can give rise to a claim because of the provisions that we've been discussing.
My Lords, that could occur.
Yes.
If I were wrong about some of the provisions, and there were, for example,
Yes.
a 4-year long stop which applied
Yes.
to the claim, it would
Yes.
still be possible in certain circumstances, including, I think, those of the present case, to recover under the warranty.
Yes.
Lords, would you forgive me one moment while I...
Yes,
Mr. Buckley.
but I think you're heavily into injury time, if not beyond it. But if there's anything else to say, briefly say it.
No, Lords, those are my submissions.
Thank you very much indeed. Mr. Stretfield James, I think it's fair to give you an opportunity to come back on anything if you want to, briefly.
I don't think so, my lord. I think we've been through the points, and it's a short, relatively short point.
Thank you. Well, thank you very much indeed to both of you for your submissions. Thank you also to all those who are involved in preparing the written cases that we found very helpful. We will consider this matter and let you know our decision in due course. Thank you very much. The court's now adjourned.